All right, hi everyone. We're gonna give it just a few more minutes as I see people are making their way into the room here. Okay, well, it is noon, so we are going to go ahead and get started. Welcome everyone to What's on File Could Be on Trial, Mastering Document Risk. I am the marketing manager for Gardner Law, and I have the privilege today of welcoming you here. I'm not Tracy Erickson, as you might guess, but I'm using her login. So if you need to contact me directly with technical questions, you can do so through the chat, but just message Tracy, because my name is Charlie, but you won't see a Charlie on there. On this exact day, 497 years ago, there was another Charlie who sacked Rome. 27 years ago on this very day, Kerry Wood pitched the greatest game of baseball that there ever was. And today, David Graham will be presenting something equally monumental, or so we hope, not to put any pressure on him. David has 37 years experience in medical device and pharmaceutical litigation cases, and a wealth of knowledge and experience to share with you across this two-part series. For the next part in this series, the following Tuesday, you'll be using the same login information. Again, reach out to me if there are any technical questions related to that. A couple brief housekeeping notes. We are going to have time at the end for questions, but throughout this webinar, feel free to post your questions in the chat. Please duly note this session is being recorded, and you can download the slides now, but we will also be making a recording of this session and the slides available to all of the registrants, and that will go live on the Gardner.law website Thursday. Without further ado, I want to pass things over to David and let him lead you on an adventure through documentation.
Thanks, Charlie. Thanks everybody for joining. As Charlie said, this is a two-part series. Well, first of all, I don't know if it'll equal those historic events, but anyway, hopefully you'll learn something. It's a subject matter that I'll tell you why I'm interested in, and it's important to me as we go along. But it's a two-part series, and the first part is not as dynamic, I don't think, because I'm going to give you a description of the structure of sort of documentation, things that are of note or of importance in litigation. And so that means we're talking about privilege and confidentiality and things like that, and trying to communicate why they're important and how firms should handle those no matter their size, because I've dealt with every size of firm from 25 people to thousands, and the problems are the same, and sometimes they're even greater with smaller firms who are up and running fast trying to get products to market and things like that. The second part of the series is a little more juicy in terms of discussion of how not to make bad documents, how to handle bad documents, how to address things that are unpleasant, and how not to create them at all. Hopefully you'll join us next week and we can talk more about things I've learned having to deal with particularly bad documents, and what they mean at trial and how they impact the image of the company in a litigation and then ultimately trial. I have litigated and tried these cases, and documents are what are the basis of how you tell your story and how you defend your product and how you defend your brand. And so that's why they're important, and they tend to be forgotten about while you're not in litigation. So hopefully this will be helpful in providing some thoughts about what your company can do, or how you can advise a company about keeping documents in order. So I gave you some of my experience. It began in a document room in Irvine, California, in a medical device case where we had 1 million documents. This was before scanning. We coded them with sheets of paper. This is the late 80s, early 90s. And I saw every kind of document and every kind of problem that arose from that, and have learned lessons over time dealing with that on what happens at trial and what happens when companies aren't keeping track of what's happening with the documents as they go along in their life, and not taking the time to change their document retention policies, privilege practices, confidentiality practices, things like that. So the agenda is today is, again, as I said before, setting out the legal structure into which documents fit in litigation. First thing I want to talk about, which I didn't put in the slides and I apologize, but I'll emphasize it as in the overlap with the next episode next week, is that one of the first mistakes that's made, and then I'll get to the slides here eventually, is whose devices and whose email addresses and whose text numbers and all those are being used. Lesson number one is don't mix personal business with business. So I'm going to say that now. We'll talk more about it, but to keep that as the first I-beam in the structure of a good document policy. It seems obvious, but when new companies are getting up and running, sometimes people are using all sorts of different addresses and platforms and phone numbers and things to leave messages and communicate that make it tremendously difficult to sort out in litigation, and often leads to things being included you rather not have be included and put before people. So that's the first lesson that I want to talk about. Secondly, I want to give you an idea of what plaintiff strategies are and why I'm talking more about why I'm talking about all this legal apparatus before we get to talking about bad documents. And that is, when plaintiffs try cases, they want to try a bad company. They don't want to just pick on it's much easier for them to make a case before the jury, especially when there's questions about causation, which there always are. It's much easier for them to make their case when the company has something to talk about that's unpleasant. One of those things can be how they've organized documents or how they talk about their products. But if you can communicate to the court in advance of being before the jury, that you're an organized company, you make rational decisions about how you organize your documents and how you determine if things are confidential and how you determine things are privileged and how you destroy documents and how you do it pursuant to a document retention policy that's well constructed, then you've won the first battle. At least the court will, in its decisions about what's in and what's out and evidentiary things, will at least assume that the company's hasn't been negligent or otherwise acted improperly with regard to handling documents. I am not going to go into the details about document retention policies. That's a whole hour or two, or confidentiality or privilege, but we'll talk about them and give pointers about ways to manage that might lead to less of a negative impact on documents that get produced in litigation. So a story about this premise. I was in a case in Minnesota, which was a multi-case, wasn't a multi-district litigation or a class action, but it was about 110 cases that were venued in district court in Minneapolis and state court. And the judge, who, as we found out, had some experience in handling documents in a medical device company, not as a judge, but as a person who was involved with a medical device company in Israel. In any event, so the plaintiffs were telling the judge that we're obviously not producing all the documents we have. We don't take care when we destroy them. We're willy-nilly in determining what's privileged and what's confidential. And we're just generally disorganized in not following the our own rules even about how we manage documents. So the judge said, and this was a medical device company in Minnesota, very reputable one, and it was our privilege to defend it. And the judge said, well, you know, I don't know. Your plaintiffs are making allegations about the care with which documents are kept and handled at the company. So why don't I go out and to the company, and this is the only time that it ever happened, but it's instructive. He said, why don't I come to the company and look at how things are organized, complaint systems and confidentiality and document retention and things like that. And of course, the client said no, right? We can't, we have to oppose that. And we thought, well, you know what? I think your company is really well organized. I think that you take great care with documents. I think you follow up and monitor document destruction and retention and have reasons for it and follow to the relative statutes of limitations and things that impact that. And I think your complaint system's pretty sophisticated. I think that the judge came to view your document, view your company and the business and see, oh, you know, I mean, medical device companies and pharmaceutical companies are impressive places, right? You have clean rooms, you have professional people that are diligently going about their business. And I said, I'd be proud to have the judge come out and visit the company. And sure enough, we finally convinced the client, excuse me, I apologize. And so the judge came out, showed him the complaint system. We showed him the little kiosk for destroying documents, you know, things like that. We had already submitted the document retention policy, and we just kind of gave him a tour of the business. And that stopped all the nonsense about how this particular company didn't care, you know, because it goes from the company's careless or negligent. That means not only are they about how they organize their business and their documents, they must be also about how they make their products. Of course, the judge not only gets to see how the documents are being handled, but they also get to see the clean room and all the great things the company's doing to produce high quality, very sophisticated medical devices. And the discussion about whether we were a careful company or not. And that had a big impact on the case and the ultimate settlement of it. No longer is the judge having to listen, or at least we're not having to listen to complaints about what a bad company we are. We can get down to the discussions about whether or not this product caused anybody harm. That's the discussion we want to have when we tell the company's story, because we believe, of course, and have good defenses too, why the product is good, why the product didn't cause harm, and ultimately leading to a good result for the company. That's a long-winded way of describing why these things are important when you get to litigation. It seems sort of imaginary, right, when you're not in litigation or you haven't experienced that. If it's a bigger company, right, maybe you constantly have litigation, right or wrong. And but it really helps when you're not dealing with, oh, geez, we don't have that. We didn't really monitor our retention policy carefully, and some of that got destroyed. Whether it was important or not, it paints a negative picture of the company. And we'll talk more about what that means in particular pieces of evidence instead of just in broad terms. So also, and I guess I'm repeating myself, but I want to say it a different way. It's very difficult to explain away negligence in how you're conducting your business as it relates to documentation. And so you don't want to spend time doing that as the lawyer for the company in a courtroom. You want to talk about the story of the company and do your explaining if you have to, dealing with negative evidence, whatever that might mean. It's never perfect, right? Whenever you're dealing with research and development, marketing and things like that, there's always pieces of paper that'll end up getting produced and that you have to deal with. But then you can deal with it, right? You can call witnesses, right? You can use other pieces of paper that explain what was said in another one. And therefore, and you can cross-examine experts who might be using negative evidence in a way that's damaging to the company. So there's a way defense lawyers can approach that, where if you're just trying to explain why you don't have documents or why you labeled everything confidential when it clearly is not, or privileged when it's clearly not, and didn't at least have some method to do that, then that's harder for lawyers. Protective orders can't cover up everything, all the mistakes. And so that is my long preamble to the why I'm talking about the material I'm talking about today, and then which will lead into the more granular discussion about practices for actually creating documents and dealing with bad documents. So this is, whoa, sorry, having issues with, there we go. So I've already talked about why it's important. I'm going to talk about spoliation. I'm going to talk about privilege, and then confidentiality and why these concepts matter. I have a few more ideas that I'll share with you other than what I just shared, and then some tips for managing it all, and then questions at the end. So if you have questions, please remember to use the chat and we'll get to those. So why is proper documentation important? Well, first of all, it's best for managing your business. Most businesses have, sophisticated IT departments and know what they want to do with regard to managing information as it relates to clinical trials, marketing, research and development, employment, and those things. These are just what I'm providing today are other things to think about as you're going along. But obviously, most important of all is not thinking about you getting sued someday, but it's proper business management. Next is what we're talking about is to protect and present your story in litigation. So you're either going to be defending a case, doesn't have to be product liability. That's what most of my experience is with, but it might be patent case. It might be an employment case or something different, or a contract case that you need to defend. You might sue somebody, right? So you want to be able to tell a story. You are talking to your lawyer and you think you can prove claims X, Y, and Z against a competitor or somebody else or a supplier or whatever it may be, and you need documentation to prove that case. So you want to have your documents in order. You need accurate information for regulators. It's never comfortable if regulators come and they happen to do audits on your documentation practices and they're not in order. And you want to avoid sanctions and litigation. So those can be fines, dismissal or sanctions, right? I mean, I shouldn't say fines, is probably too limited. Sanctions can be anything from fines to the lawyer gets disqualified or something. Dismissal and loss of the case, which is rare, but it does happen. What is another negative result is adverse evidentiary presumption against the company or individual. That is, in the absence of some document you should have, there's a presumption against the company and an instruction to the jury. Well, company X didn't have this document, so you can presume that it didn't exist or it said something that's not favorable to the company. So I luckily have not been involved where we've had dismissal or loss of the case. I've been involved though where we've had evidentiary presumptions against the company. None of them were fatal, thank goodness, but we still had to deal with it in our case to the jury. So the first concept I want to talk about, which is, the most troublesome, is spoliation. So spoliation is getting rid of evidence in a negligent or intentional way that would be related to the case, right? This is why document hold letters are sent out to employees who might have relevant information as soon as a case is somebody thinks that a case may arise. So we can talk about that, and I will now, but we'll talk about it probably some more next week. But it's an important concept to think about. And what happens is you do something carelessly, you didn't mean to do it, you were really busy, suddenly documents weren't retained that you should have been retained, and then they can't be produced if they're relevant in litigation, and then you got to deal with it. So it's not always the case that you tried to do anything or hiding anything. That does happen, unfortunately, but it's usually a case of negligence, not necessarily pejoratively negligent. It just didn't get done. So the consequences are listed there again. So you have a duty to preserve evidence. So this is in the law. You can't, gee, we might get in trouble. This guy called up and complained and said he's gonna bring call his lawyer and then suddenly get รือof things that were related to that person's, not only a specific case, but whatever device or drug they're taking. Or if it's an employee, whatever emails or communications might have been shared with that employee that looked great, you have to preserve the evidence in the natural course of business or pursuant to your document retention policy, and that's the duty. There's no question about that duty. The only question comes up is timing usually. We didn't preserve the evidence beginning on a certain date because we didn't believe or have any facts that led us to believe that there was a possibility of litigation. Obviously, your outside lawyers are going to be very conservative about this. And as soon as they think there's a possibility of litigation, you should have a litigation hold in place and notify people to preserve documents and suspend automatic destruction of documents through the IT department or wherever. Always include the IT department, as they usually have the levers to decide what's around and what's not around. As we know, deleting something from your personal computer, I don't mean personal, the one you own, I mean the computer you're working on in your job doesn't delete things. So in any event, that's the duty to preserve. It needs to be taken seriously. It applies to every kind of document you can think of, including voicemail and text And it might even include platforms where you communicate, social media platforms, if the company especially markets on them, and which we'll talk about more next week. But, you know, you gotta, when you're thinking this through, the plaintiffs are going to broaden this as far as possible to include all the ways you either conclude amongst yourselves in a company, or how you communicate with the outside world. And that's why it's so important, as I said in the beginning of the presentation, to have a handle on what mediums are being used for communication. So some of the recent cases I just listed here. One, the Mazier case, it was a employment case, led to dismissal with prejudice. The Jones v. Riot Hospitality Group was a case, a contract case, and it led to an adverse inference instruction and permission to present evidence of spoliation. So not only was there an adverse, so back to my original point, in this case, not only did the judge say there's going to be an inference in the absence of the document that the evidence is unfavorable to the company, you get to talk about why the evidence isn't around, which just makes the company look bad. And again, as I've said before, it's not the individual acts always that are being tried, but the company as a whole and its brand. And plaintiffs will do whatever they can to paint the company as a bad company that's not operating in good faith. And almost all companies are operating in good faith, especially in the medical device and drug industry, because it's highly regulated. And so the costs are not just related to litigation, but also regulation and the detailed documentation that occurs as it relates to bringing products to market. But anyway, that's the problem with documents that for some reason no longer exist. The determination by the court, of course, your opponent's always going to be arguing that intent is often the driving factor, and that's true. So the judge is going to, when evaluating how to handle the non-existence of, and it's almost always that, of evidence, is, well, what did the company do? I mean, is this just something that happened because the employee didn't get the instructions quite right, the timing of the installation of the apparatus to prevent such destruction, or the schedules weren't in place yet because it was a new company? An important person suddenly wasn't working in IT or as a head of a department or left, and so something happened with instructions about it. You know, is it something like that, or is it, boy, this seems to be a pattern where certain documents are not available, and, well, we don't have an explanation for it all. We're going to make the presumption that it at least is negligent and not just a mistake. So the next concept I want to discuss is privilege. And again, we're not trying to go into all the details around privilege, but give you some pointers about how to manage it as you're going along. So first of all, what is it? Well, it's communications between a lawyer and their client related to getting advice, right? It's not just a lawyer sitting in meetings in a company, an in-house lawyer, for example, or an outside lawyer being put on the phone in every meeting, and it suddenly becomes privileged. But you're talking about, you know, raising money for the company where there's no particular legal questions. It's just strategy, right? So it has to be legal advice or providing some service related to legal advice. So that's about all I'll say about that without going into too many details. But lots of times we get calls not related to litigation, where, excuse me, where they're asking us our opinion about something, and that's clearly privileged. So the protection extends to any information exchanged during these privileged communications and encompasses verbal, written communication, all types of messaging, and it might extend to communications that aren't specifically documented, but that happen as you go and are talking about a particular issue where legal advice is being imparted. So what do I want to say about this? I'll give you an example of when, to start talking about privilege. Obviously, when you call your lawyer and you get advice, it's privileged. But sometimes we're talking about, documents will be prepared. Like I had a client, we were, a couple of us were talking to a client about a issue with a device and whether there should be an MDR and then maybe ultimately a recall. And documents were being created for the purpose of explaining to us, the lawyers, what was happening, right? Which it was very instructive, and what the analytical steps were, and then we were tasked with fitting in those analytical steps into the regulatory structure around MDRs and recalls. And so that document, at least the iteration we're looking at, should be privileged because it's produced specifically for getting legal advice, right? It may also be used, now that privilege, so the document should be marked privilege, right? That privilege might go away as the document is shared with other people and used in other ways, if it has multi-uses, right? But at least in the beginning, it should be marked privilege because its specific purpose was to get legal advice, legal regulatory advice. And why not mark it? It's not inappropriate. Now, when litigation arises, you might determine that, boy, we shared that with everybody. And while the lawyers looked at it, there might be one version of it that is privileged, but ultimately some other version that we shared with regulators, right? When we were, excuse me, trying to explain our analysis of what we're going to do about this particular device malfunction, may not be. So, but you don't have a chance to preserve the privilege if you don't mark it in the first place and keep a record of that and have a place for it to go. Oh. So, excuse me. What's another kind of privilege? Well, it's work product privilege, and you've probably all heard of this and had it in law school or deal with it every day, maybe. But work product privilege protects documents and tangible things prepared in anticipation of litigation. And the protection extends to documents that include attorneys' mental impressions, conclusions, opinions, or legal theories. So my files and the notes that I've put together preparing a defense or preparing a prosecution of a company's case are obviously privileged. I have argued successfully that also notes you have working with me, preparing a defense, like say you're going to be a witness, right? And you're the director of research and development. And I'm preparing you for testifying, or you're helping me answer interrogatories. Your notes and thoughts about those answers, whether it be interrogatories or a verbal testimony, are arguably work product as well. It's not just something that attorneys hold. in my opinion. It's the whole team, and that team may include both lawyers and business people who are not lawyers and purveyors of legal advice. The classic extension of that privilege is to your attorney's mental impressions, but I've argued, and it has been argued successfully, that if we're working on something together and you're helping me prepare the defense, your mental impressions and notes as well are privileged. Doesn't always, it depends on a lot of different factors, but we could spend a lot on that and it may not be helpful. So what does that mean? That means if you're a company person and you have a litigation, even if it's small, and you're working with a lawyer about, an answer to a complaint or a response to a demand or something, you should keep that separate from normal documents. Now, hopefully you would, because your lawyers would be walking you through all this, but it's important to think ahead and market work product privilege. So those notes related to the defense or prosecution of a case are kept separate. And it really makes things easier if you actually get to litigation where you have to produce documents. So for those who are not familiar with the litigation process, you would get a demand for documents, and the demand would say all documents relating to the research and development of the product X. And all those, there may be documents in that are privileged. Most of them should be scientific, you would think, or business documents, right? But you never know. You might have asked along the way some legal questions and they're in the files and you don't want to produce those because you don't have to, because they're related to advice you got from your attorney. Well, there's a privilege log that you would prepare in the litigation, so you can show the other side, we withheld these documents. Here's why. Obviously, the contents are not disclosed, but privilege doesn't apply to what happened and when it happened. It only applies, it doesn't apply to when it happened. It may not apply to how it happened. It only applies to what was communicated. What's the privilege content? So anyway, that's why it's important to have some thinking about privilege before litigation comes, because eventually you're going to have to explain why you've withheld documents and they're included on a privilege log. So what are the exceptions for privilege? Attorney misconduct, that's you did something so inappropriate in the defense and conduct of the case or whatever that you no longer are given that right. Crime fraud exception, that comes up when I do False Claims Act cases. A lot of opponents or whistleblowers argue that, well, could lead to a crime, so the privilege shouldn't apply to certain documents that relate to how the compliance policy was developed, because it clearly was fraudulent from the beginning, and so the crime fraud exception should apply. And of course, we're not even close to crimes at this point. We're just dealing with coding issues and Medicare fraud issues that aren't a crime under most definitions. But it is an exception that comes up and can come also up in also medical device and drug cases, especially as it relates to pricing and things like that. And the other is you waive it. So, excuse me. So waiver is the one that is really most relevant to our discussion today. That's the point of having some being tuned in to privilege as the life of the company is going along, and as you receive advice from lawyers, because if you've never marked it privileged, you've never taken any steps to protect the information, the advice given by lawyers, then you're probably going to be an argument that you waive that privilege because you'll end up sharing with people, and then you never can exclude it at all. Now, your life obviously is not going to be spent necessarily worrying about these designations. But as you're in discussions with lawyers, you might ask your counsel, boy, I called you about this. Is there anything I should do with these communications? And you would hope that there's some methodology in the company that my emails with my lawyers are getting somehow separated out. Not always the case, though. And not everyone may end up privileged, but if you never try, then you end up having an argument that the privilege has been waived and that you no longer can claim it. So these are just a summary of what I've told you, but slides are helpful sometimes. Mark or otherwise designate the documents. We've already talked about that. Separate them. So you should have in document retention policies a way for the company, once designated, to have a place to put them. Of course, most of them are electronic, right? Nowadays, they're not just stacks of paper that you put in a folder named privileged. So, so that's important. And then try to do it as a matter of business practice before litigation. People are running fast. It's hard, right? You're trying to resolve an issue that keeps the product on schedule, deals with a regulator, deals with people investing in the company, deals with employees. So sometimes it's difficult to, at the end of whatever resolution you come to on whatever issue you're facing, to go back out and look and separate out the documents that you think might be privileged. But it's a good practice, and it's better than trying to do it later when maybe the documents have been disseminated beyond the circle of people that would allow for the privilege. Confidentiality. So this is an important concept, not just for litigation purposes. It's because you want to protect the interests and the assets of the company, especially when it comes to intellectual property. I mean, that's what medical device and pharmaceutical companies are dealing with, is invention, right? And innovation. So it refers to the practice of keeping specific information private and inaccessible to unauthorized individuals or the public. So this applies to data, customer list, financial records, research and development, employment records. I mean, there's other categories. Those are examples, right? That's not meant to be exhaustive, but it's an important concept, and it always comes up in litigation, and I'll explain why. Excuse me. So, I mean, but why do you do it? It's for your competitive advantage in protecting the company's assets. That someday you want to sell the company, sell the intellectual property, sell the device, whatever it is. You can't do it if somehow the world already knows how you do it. So, and are copying it. So that's obviously paramount is business, secondarily litigation. So in lawsuits, so generally confidential information has to be produced. So if I get a document request for all documents, again, relating to research and development, I got to produce those. But what do you do with them? Well, you can designate them confidential, so dissemination is limited. You can designate them as confidential, attorney's eyes only, and then only the attorneys involved in the case can look at them if they're highly sensitive. So usually you have two tranches or two categories of documents. And this is all subsumed within a protective order, which I'll talk about in a little more detail in a minute. But that's why it's important in the company to already have been protecting the information, and most do. So with a proper protective order, the court will prevent dissemination beyond the case. and allow for destruction of the documents by each side, right? At the end of the case. There's a lot of, some judges are more amenable and to broad protective orders to protect intellectual property. Most allow for it because it keeps the case moving. Arguing about it, long as it can be presented to a fact finder, it doesn't, it shouldn't matter. I mean, at least that's always my position. Let's just come to an agreement about what we're going to do with it, and then we can proceed with presenting evidence. I should say something about privilege too and protective orders, just to go backwards for 1 second. And that is, in a lot of protective order now, there's a waiver provision. In other words, if you inadvertently produce privileged documents, they have to be sent back by the other side, as long as it's not endemic. But if that's the case, so just, there are provisions in protective orders to allow for clawback of privileged documents. So anyway, back to confidentiality. To be an integral part of a document retention policy, both their retention and their destruction. So you should have special places and ways for that employees know about where they could, how they get rid of the documents, right? How they keep them and what should be kept, but also what's the timely and appropriate way to get rid of them and not carry them around on devices they shouldn't, and all those things that might lead to the improper dissemination of the information that's important to the company. Obviously, you have to monitor compliance and execution periodically. You have to actually look at what's in your files and how things are being kept, and check in with employees and say, what should be kept, how many copies and things like that. So you should have a plan for that. And as you go along, excuse me, and many companies do, but it's important. It really makes things a lot easier in litigation to be able to tell the judge, yep, this stuff's designated confidential. Judge, why? Well, because it relates to all these, our research and development and these particular methods of doing things and these customers and these clinical trials and things like that. And so they're very important to the company. And here's how we've taken care of it since we began, right? We've always treated this as important information. It's just not now for litigation, right? We've always had a plan, implemented the plan, verified the plan, or monitored and verified the plan as we've gone. The judge can go, okay, it's confidential, right? You care about it, it's of value, and you have treated it as such. So anyway, here's some more, basically what I've just set out, and since we're getting a little pinched on time, I won't say much more about this slide, except for emphasizing that employees know what to do with the information. So train employees, provide information on proper creation, very important. Because a lot of people just keep stuff, right? And not sure where they're going to keep them. So every once in a while, you got to say, hey, by the way, if you happen to have documents related to this particular product or this particular trial or this particular whatever, we need to make sure that it's in a place that's safe, it's not being disseminated, and is being destroyed if it's appropriate to do so in the proper manner. So tell people that. Document retention policies. You need to have one. I don't know what more to say about it in that. Even if it's a simple one at the beginning of your beginning of the life of the company, you need to have one. It needs to have separate categories for employment, research and development, clinical trials, marketing, all the different things that have different regulatory and legal statutes of limitations and requirements. It's obviously important because you're a highly regulated company, and It's a nightmare if you don't have one, because the first thing that opponents are going to ask you about is, excuse me, I want a copy of the document retention policy, and you'll have to produce it. And because they want to see what's supposed to be there, how documents were supposed to be handled. I always ask for one, unless it's an individual, like the plaintiff is an individual who's alleging harm from a device or a drug. Obviously, they don't have a document retention policy, but obviously our company does, and it's really helpful to be able to say, yep, we have one, and it's really sophisticated. Here's who's in charge of it, which is very important. Here's who can talk about it. So under the designate someone to implement it, you have to have also people who can talk about it, right? In case that person ends up being deposed, right? And that happens. Document custodians get deposed just about where documents are, not even about the facts of a particular claim of negligence or breach of contract or whatever it is. So it's very important. Obviously, you have extensive in the industry regulatory documentation requirements, which might take care of a lot of this, but it's important to maintain it. Monitor it from compliance, even if it's just to make sure proper retention and destruction is happening. And that protects the interests of the company in many ways. And then, like I've repeated, train employees about it. It doesn't do any good if a new employee comes in and they happen to be fairly important. Maybe they're managing a department or something, and they know it exists, right? You give them to it, right? And they kind of clued in, but they're not really. They don't know how your particular company is managing it and dealing with it during the course of business. And so you want to prevent immediately any inappropriate document practices that might not fit with what you want to do. So if you ever have any question about document retention policies, it's worth having people review them who are outside the company. Not always the case that it's lawyers, but lots of lawyers have experience with them and can help you with making sure that they're proper regulatory professionals, obviously, some of which you might be on this call, obviously are super set of eyes to have on it. And then I just dropped a thought about them. Well, I'll come back to it. But in any event, it's an important part of a business and a very important part of litigation right from the get-go. Somebody will ask for it. A couple other notes about this. You need to make sure that business leaders, C-suite people I know that can be delicate, but are tuned into its importance, just like they should be tuned into compliance plans related to fraud and abuse or things like that. I think this is pretty important and sometimes gets left by the wayside. And you get managers or executives in depositions, and they should at least be somewhat conversant about it. Obviously, they will have delegated the implementation of it to a team of people, including some managers and IT people, and can properly defer to them, but to have, not even enough knowledge to answer whether they follow it is not very helpful. Finally, the IT department is paramount to this particular subject because they pull the levers and decide if it's being monitored and implemented in things. And technology changes, platforms change, and all that has to be taken into consideration as you go. So it's and not only those things, but also what's being done about social media and things like that to the extent they're part of the business, and they often are in the case. So next time I am done, and we'll have time for 5 minutes for questions. We're going to talk about the bad documents. It's much more fun and interesting. Discussion of how to not create bad documents, how to communicate in emails, text, and phone, believe it or not, actually calling somebody, or in person, actually walking down the hall and talking to somebody to the extent we're not working remotely, and how we should document complaints and resolution of those complaints, and what to do when bad documents are created. In other words, they get created, right? People get emotional. People repeat things in documents, and even though they're not of the opinion of the original issue, it gets, it takes on a life, and how to deal with that. And I think it always has, hopefully I'll have some entertaining examples and hopefully some creative solutions to limit the creation of bad documents. So I'm going to go back here and look at the chat. First questions. If you have any, you can put them in here.
Hi, David. Looks like we've got one in the question section.
Okay, you might have to repeat it because I'm not bringing it up.
Yes, I gotcha.
Okay, thank you, Charlie.
From Sanjeev Dahiwadkar. I apologize if I'm butchering that name, Sanjeev. But Sanjeev asks, if you share information that you communicated with our attorney with your other employees and advisors, does it lose attorney-client privilege?
Not necessarily. Depends what the purpose is. If you're implementing the advice. It depends on how widely. I'm not giving you a very good answer. Let me do better. So generally the answer is if you're communicating that our lawyers said this is the approach we need to take when dealing with problem X, or if creating this, then it should maintain its privilege to a certain to the extent you're repeating that advice. Now the full all the documents that might be created as a result of implementing the advice, for example, how to deal with marketing documents, or maybe how to deal with speaker bureaus or something like that, obviously aren't going to necessarily be privileged, but imparting the initial advice is worthy of trying to maintain the privilege. I hope that's helpful. If it's just disseminated to 15 people in an email saying our attorney says, may not save it, but it's worth a try. Any other questions? Having not seen any other questions, that's the end of our presentation. And I appreciate everybody joining us today.
All right, thanks everyone. I am looking for the end webinar button at the moment.